The morning I installed my backup generator shed, I had no idea it would trigger the worst 6 months of my life and expose a criminal conspiracy that would make national headlines. My name is Owen Reeves, and I had just moved into the Meadowbrook Estates subdivision in Naperville, Illinois, a suburb about 30 miles west of Chicago. The house was perfect, a 3-bedroom ranch with a finished basement where I ran my home-based IT consulting business. The neighborhood seemed quiet, the streets were clean, and the HOA fees seemed reasonable at $200 a month. I signed the papers in early January 2025, right as a series of rolling blackouts had been hitting the Chicago suburbs due to an aging power grid struggling with increased demand. The power outages were more than an inconvenience for me. They were a business killer. I had clients across 3 time zones who depended on me for 24/7 network monitoring and emergency support. Losing power meant losing income, and after the 3rd outage in 2 weeks cost me nearly $5,000 in lost contracts, I knew I needed a solution. I did my research carefully. I consulted with an electrical contractor named Mike Chen, who had excellent reviews and 20 years of experience. He recommended a whole-house natural gas backup generator, a Generac model that would automatically kick in within 10 seconds of a power loss. The generator itself cost $8,000, and the installation would run another $3,000. But Mike strongly advised one more thing. "You need a proper shelter for this unit," Mike said, walking around my side yard where we planned to install it. "I know the generator is rated for outdoor use, but in Illinois weather, you're going to extend its life significantly with protection from the elements. Plus, the electrical components will be much more reliable. I've seen too many of these fail prematurely from moisture getting into the control panels during heavy snow or ice storms." That made sense to me. I was already spending $11,000. What was another $1,500 for a small shed to protect my investment? Mike drew up plans for a simple structure, 8 feet by 6 feet, with adequate ventilation, proper clearances for fire safety, and a concrete pad foundation. It would sit on the side of my house, barely visible from the street, tucked between my property and the fence line. I pulled my copy of the HOA covenants that I had received at closing. I read through every page, looking for restrictions on generators or outbuildings. The document mentioned that structures visible from the street must receive architectural approval, and that no permanent structures may be erected without HOA review. The language seemed straightforward enough. Since my shed would be on the side yard, barely visible from the street and certainly not in front, I figured I was fine. Still, I wanted to do things properly. I submitted an architectural review request to the Meadowbrook Estates HOA on February 1st. I included detailed plans, photos showing the proposed location, specifications for the generator, and a letter from Mike explaining the necessity of weather protection for the electrical equipment. I noted that the shed would match my house's existing siding and roof shingles, making it aesthetically consistent with the property. 2 weeks passed with no response. I called the HOA management company, Prestige Property Management, and was told my request was under review. Another week went by. Finally, on February 24th, I received a letter. Not an approval, but a notice that my request had been escalated to the architectural committee and that I should expect a response within 30 days. The problem was, I had already scheduled the generator installation for March 3rd. Mike had a tight schedule, and pushing the date back would mean waiting until late April. Spring storm season would be in full swing by then, and I couldn't afford more outages. I read the HOA rules again. this time with a lawyer friend helping me interpret the language. According to the covenants, the HOA had 30 days to respond to architectural requests. After 30 days, if there was no response, the request was considered approved by default. I had submitted my request on February 1st. 30 days would be March 3rd, the exact day of my scheduled installation. I called Prestige Property Management again to confirm they had received my submission. They verified the February 1st date and told me the architectural committee was still reviewing it. If I don't hear back by March 3rd, can I proceed with the installation? I asked. The woman on the phone, who identified herself as Sandra, hesitated. Well, according to the bylaws, you could technically argue automatic approval, but I'd really recommend waiting for explicit approval. I'll wait until March 3rd, I said. But if I haven't heard anything by then, I'm moving forward. I've been more than patient, and I have business operations that depend on reliable power. March 3rd arrived with no response from the HOA. Mike and his crew showed up at 8 in the morning. We poured the concrete pad, installed the generator, ran the gas line and electrical connections, and built the shed around it. The whole job took 2 days. By March 4th in the evening, I had a fully functional backup generator in a neat, attractive shed that matched my house perfectly. The shed had been standing for exactly 48 hours when I met Patricia Palmer. I was checking my mail on March 6th when a silver Mercedes SUV pulled up to my driveway. A woman in her late 40s stepped out, wearing pressed slacks and a blazer despite the casual suburban setting. Her blonde hair was cut in that specific style that seemed to be standard issue for a certain type of suburban woman, and her expression already looked like she had smelled something unpleasant. "Are you Owen Reeves?" she asked, walking toward me with purpose. "That's me. Can I help you?" "I'm Patricia Palmer, president of the Meadowbrook Estates Homeowners Association. I'm here about the unauthorized structure you've erected on your property." I felt my stomach sink, but kept my voice calm. The generator shed. I submitted an architectural review request on February 1st. I waited the required 30 days and received no response, which according to the covenants constitutes automatic approval. Patricia's expression could have frozen water. That's not how it works. The 30-day rule is a guideline, not an absolute. The architectural committee has the right to take whatever time is necessary to properly review submissions. And in this case, your request was denied. Denied. I never received any denial letter. She reached into a leather portfolio she was carrying and pulled out a single sheet of paper. "This denial was sent to your address on March 2nd. You should have received it by now." I looked at the date on the letter. March 2nd. I never got this, and even if you sent it on March 2nd, that's past the 30-day window from my February 1st submission. The 30-day clock doesn't start until the architectural committee receives a complete application with all required documentation, Patricia said, her voice taking on a lecturing tone. Your submission was missing several required elements, such as the property survey showing exact setback distances, proof of homeowners insurance covering the structure, a detailed materials list, 3 exterior color samples. All of these are outlined in the architectural review guidelines. I was never given architectural review guidelines, I said. The only documents I received at closing were the basic covenants and the fee schedule. It's every homeowner's responsibility to request the complete guidelines from the management company. Regardless, the structure is not approved and must be removed immediately. I took a deep breath, trying to keep my frustration in check. "Look, Mrs. Palmer, I understand there may have been some miscommunication here, but the generator and its shelter are necessary for my business operations. I work from home and need reliable power. The electrical contractor who installed this explicitly stated that weather protection is essential for the equipment's longevity and safety. That's not my concern, Patricia said flatly. The structure violates multiple HOA provisions. It's too close to the property line, it wasn't pre-approved, and frankly, it's an eyesore that diminishes property values for the entire community. An eyesore. It's a 6x8 shed that matches my house exactly and is barely visible from the street. The architectural committee has made its decision. You have 14 days to remove the structure, or the HOA will begin daily fining procedures at $100 per day. If the fines exceed $5,000, we can file a lien against your property. Patricia handed me an official notice, turned on her heel, and walked back to her Mercedes without another word. I stood there holding the notice, my mind racing. This couldn't be happening. I had followed the rules as I understood them. I had tried to do everything properly. And now I was being threatened with thousands in fines for trying to protect my business and my expensive equipment. That evening, I called Mike Chen and explained the situation. "That's complete garbage," Mike said immediately. "Look, I'm a licensed electrical contractor in Illinois, and I'm telling you that what I told you about equipment protection isn't just a recommendation. It's common sense. Generators last maybe 5 to 7 years exposed to full weather. With proper shelter, they'll go 15 years or more. But more importantly, the National Electrical Code has specific provisions about protecting electrical equipment from the elements. The National Electrical Code, that's an official thing. It's the Bible for electrical work in the United States. NEC Article 110 covers general requirements for electrical installations, including protecting equipment from deterioration. Let me look up the exact language. I heard papers shuffling. Here it is. Article 110.1 states that equipment must be protected from deterioration and must be suitable for the environment. In Illinois weather, a generator sitting completely exposed to snow, ice, rain, and temperature extremes needs some form of protection to maintain code compliance over its operational life. So, I can argue that the shed is actually required for code compliance. You can more than argue it, it's factual. I can write you a letter stating that the shelter was installed as part of the electrical system to ensure long-term code compliance and equipment protection. I'd recommend you also get the local electrical inspector involved. When did the installation get inspected? I paused. Inspected? Yeah, you pulled a permit for this work, right? My stomach dropped. I didn't know I needed one. Mike groaned. Owen, any generator installation requires an electrical permit and inspection. That's not an HOA thing, that's a building code requirement. Why didn't you tell me you hadn't pulled the permit? I thought you were handling that as part of the installation. No, the homeowner always pulls the permit. It's your property. But okay, we need to fix this now. Call the Naperville Building Department first thing tomorrow and tell them you need to get a permit for work that's already been completed. They'll probably fine you a double permit fee, but then they'll send an inspector out. When the inspector sees the installation, he'll verify everything is to code, and that will include the weather protection for the equipment. I called the building department the next morning and spoke with a clerk named Jennifer, who sounded like she dealt with situations like mine regularly. "So you installed a generator without pulling a permit first," she said with a sigh. "That happens more than you'd think. The penalty fee for after-the-fact permitting is double the normal rate, so that'll be $300 instead of $150. We'll need the installation contractor's license information, full specifications on the generator, and photos of the installation. Then we'll schedule an inspection." I provided all the information and paid the fee. The inspection was scheduled for March 12th, 6 days away. In the meantime, I researched the National Electrical Code requirements Mike had mentioned. He was absolutely right. Article 110.11 explicitly stated that equipment must be suitable for the environment in which it's installed. Illinois weather was brutal temperature swings from below zero in winter to over 90 in summer, heavy snow, ice storms, severe thunderstorms. An electrical inspector could reasonably argue that a generator needed weather protection to maintain code compliance. I printed out the relevant NEC articles and prepared a response to the HOA. I cited the electrical code requirements, included Mike's letter explaining the necessity of weather protection, and stated that I was in the process of obtaining the proper electrical permit and inspection. I sent this response to both Patricia Palmer and Prestige Property Management on March 10th via certified mail. The electrical inspector arrived on March 12th at 2 in the afternoon. His name was Ron Matthews, a man in his 60s with gray hair and the tired expression of someone who had seen every possible electrical disaster in his career. Generator installation, after the fact permit, he said, reviewing his clipboard. Let's take a look. I walked him around to the side yard and showed him the shed. He opened the door and examined the generator carefully, checking the electrical connections, the gas line, the clearances around the unit, and the ventilation in the shed. "Who did the installation?" he asked. "Mike Chen from Chen Electric." Ron nodded approvingly. "Mike does good work. Let me check a few more things." He spent 20 minutes going over every detail of the installation. Finally, he straightened up and made some notes on his inspection form. "Everything looks good," he said. "The installation meets code. The generator is properly rated, connections are correct, clearances are appropriate, and the shelter provides adequate protection for the electrical components while maintaining proper ventilation. Actually, I'm glad to see the shelter. Too many people leave these units completely exposed. So the shelter is considered necessary?" I asked, trying to keep the hope out of my voice. Ron looked at me with the knowing expression of someone who suspected there was more to this question. "Let me put it this way. Is the shelter required by code, not explicitly? Could this generator operate without it? Yes. But would I, as an electrical inspector, recommend weather protection for a critical electrical system that costs this much money? Absolutely. And could I make an argument that, per NEC Article 110.11, this protection is necessary to prevent deterioration and ensure the equipment remains suitable for its environment throughout its service life? Yes, I could make that argument. Would you be willing to put that in writing?" Ron studied me for a moment. "HOA problems? How did you guess?" "Because that's the only reason anyone ever asks that question." "Yeah, I can write you a letter. Give me your email." I could have hugged him. Ron sent me the letter that same evening. It was perfect professional, citing specific code sections, and clearly stating that weather protection was highly recommended and consistent with National Electrical Code requirements for equipment protection and longevity in the Illinois climate. I immediately forwarded the letter to Patricia Palmer and Prestige Property Management, along with a copy of the past electrical inspection. Patricia's response came 2 days later on March 14th. "It was not what I hoped for. Mr. Reeves," the letter began. "While we acknowledge receipt of your electrical inspection approval, this does not supersede HOA architectural requirements. The structure on your property was not approved by the Architectural Committee and remains in violation of Meadowbrook Estates covenants. Your 14-day removal deadline has now passed. Effective March 7th, You are being fined $100 per day until the structure is removed. You currently owe $800, and this amount will continue to increase daily. I couldn't believe what I was reading. They were actually going through with the fines, despite the electrical inspector's letter, despite the code requirements, despite everything. I called a lawyer the next morning. His name was David Fitzgerald, and he specialized in HOA disputes. "Bring me everything," David said when I explained the situation. "All the documents, letters, the inspection report, everything." I met with him that afternoon in his office in downtown Naperville. David was in his 40s with dark hair starting to gray at the temples and sharp, intelligent eyes. He reviewed all my documents carefully. "Okay," he finally said. "Here's the situation. You did make a mistake by not pulling the electrical permit before installation, but you've corrected that, and the installation passed inspection. You also made a procedural error by installing during the 30-day review window instead of after it expired, but your argument about automatic approval after 30 days has merit. The HOA's position that they can take unlimited time to review is questionable. So, what do? We fight back, but smartly. First, I'm going to send them a letter citing the electrical code requirements and making it clear that the shelter is a necessary component of a legal electrical installation. Second, I'm going to argue that their denial of your architectural request was arbitrary and capricious, because they can't cite any legitimate aesthetic or property value concerns when the structure is barely visible and matches your house. Third, I'm going to tell them that if they continue with the fines, we'll take them to court and seek damages plus legal fees. Will that work? David leaned back in his chair. It depends on how reasonable they want to be. Some HOAs back down when they realize a homeowner is serious about fighting. Others dig in out of principle or power tripping. Patricia Palmer's name is familiar to me. She's been president of your HOA for 6 years, and I've heard she runs it like a dictator. This might get ugly. It got ugly. David sent his letter on March 16th. Patricia's response came back on March 19th, and it was clear she had no intention of backing down. The HOA had hired its own lawyer, a firm called Morrison and Associates that apparently specialized in representing HOAs. Their letter was aggressive, threatening, and made several concerning claims. According to Morrison and Associates, the HOA covenants gave the architectural committee sole and absolute discretion over all exterior modifications. They claimed my generator shed violated setback requirements, though they didn't specify which ones. They stated that multiple neighbors had complained about the structure's appearance, though no one had provided any names or specific complaints. And they made it clear the fines would continue and escalate. But there was something else in the letter that caught David's attention. "Look at this paragraph," he said, pointing to a section near the end. "They're claiming the shed is too close to the property line and violates the 3-foot setback requirement. But according to the survey you showed me, the shed is 4 feet from the property line." That's right. Mike was very careful about that. Then they're either lying or working from incorrect information. We need to get a current survey done to prove your case, and I want to start looking deeper into this HOA. Something doesn't smell right. I hired a surveyor who came out on March 22nd and confirmed that my shed was exactly 4 feet and 2 inches from the property line, well within the setback requirements. Meanwhile, David started doing background research on the Meadowbrook Estates HOA and Patricia Palmer. What he found was disturbing. "I've been talking to other attorneys who have dealt with your HOA," David told me during a phone call on March 24th. "There's a pattern here. Over the past 3 years, the HOA has filed liens against 7 different properties for various violations. In each case, when the homeowner couldn't pay the accumulated fines, the HOA forced the sale of the property through foreclosure. And here's where it gets interesting. In 4 of those 7 cases, the properties were purchased by an investment company called Meadowbrook Properties, LLC. Okay, so an investment company bought foreclosed homes. That doesn't seem that unusual. It wouldn't be, except I looked up Meadowbrook Properties, LLC in the Illinois Business Registry. Want to guess who the registered agent is? Who? Russell Palmer, Patricia Palmer's husband. I felt my blood run cold. Are you saying what I think you're saying? I'm saying it looks like Patricia Palmer has been using her position as HOA president to target homeowners, rack up fines, force foreclosures, and then her husband's company buys the properties at below market prices. If that's what's happening, it's fraud. It's a breach of fiduciary duty, and it's probably several other crimes. What do? We keep digging and we prepare for court. Your hearing is in 2 weeks. In the meantime, I'm going to contact some of the previous homeowners who lost their properties and see if they'll talk to me. The next 2 weeks were some of the most stressful of my life. My fines continued to accumulate. The HOA was now claiming I owed over $2,000. I was getting threatening letters every few days. Patricia had apparently rallied some of the neighbors against me, and I started receiving cold stares when I checked my mail or took out the trash. But David was building a case. He managed to contact 3 of the previous homeowners who had lost properties to HOA foreclosures. All 3 told similar stories. Patricia had targeted them over minor violations, refused to work with them on payment plans, and pushed for foreclosure as quickly as possible. One woman, Janet Kowalski, had lost her home over $3,500 in fines for having the wrong shade of beige on her front door. I tried to repaint it, Janet told David, her voice breaking during the phone call he had me listen to. I repainted it 3 times, and each time she said it was still wrong. The fines kept adding up, and I couldn't afford to pay them. I lost my home over the color of my door. David also discovered that Russell Palmer's company had made over $3 million flipping the foreclosed properties from Meadowbrook Estates over the past 3 years. The court hearing was scheduled for April 8th in the DuPage County Courthouse in Wheaton, Illinois. The matter was listed as Meadowbrook Estates HOA vs. Owen Reeves and was assigned to Judge Margaret Henderson. I dressed in my best suit and met David at the courthouse at 8:30 in the morning. Patricia Palmer was already there with her lawyer, Stephen Morrison, a slick-looking man in his 50s with silver hair and an expensive suit. The hearing began at 9 o'clock. Judge Henderson was a woman in her late 50s with short gray hair and a no-nonsense demeanor. Morrison presented the HOA's case first. He argued that I had violated clear architectural guidelines, that the shed was an eyesore, that it violated setback requirements, and that the HOA had every right to enforce its covenants through fines. Your Honor, Morrison said, homeowners associations exist to maintain property values and aesthetic standards. When Mr. Reeves chose to purchase in Meadowbrook Estates, he agreed to abide by these standards. He cannot now claim that his personal business needs override the rights of the community. David stood up for my defense. He was calm, methodical, and devastating. Your Honor, this case is not about HOA enforcement of reasonable standards. This case is about a homeowner who attempted to comply with HOA procedures, installed a legally required electrical system with proper weather protection, as recommended by both the electrical contractor and the city inspector, and is now being targeted with excessive fines for a structure that complies with all relevant codes and setbacks. David presented the surveyor's report showing the shed was within setback requirements. He presented the electrical inspector's letter explaining the necessity of weather protection. He presented the timeline showing my architectural request and the HOA's failure to respond within 30 days. But then David played his trump card. "Your Honor, I'd like to enter into evidence documents showing a pattern of behavior by the HOA president, Patricia Palmer. That suggests these fines are not being levied in good faith, but rather as part of a scheme to force foreclosures and benefit a company owned by Mrs. Palmer's husband." Morrison jumped to his feet. "Objection. This is completely irrelevant to the matter at hand. It's directly relevant to whether the HOA is acting in good faith," David countered. "I have evidence of 7 foreclosures initiated by this HOA in the past 3 years, 4 of which resulted in properties being purchased by Meadowbrook Properties, LLC, which is owned by Russell Palmer, the husband of the HOA president. I have testimony from previous homeowners describing similar patterns of excessive fines for minor violations. This goes to the credibility and intent of the HOA's actions." Judge Henderson looked very interested. "I'll allow it. Mr. Morrison, does Mrs. Palmer's husband own Meadowbrook Properties?" Morrison looked uncomfortable. "I'm not aware of the details of Mrs. Palmer's family business arrangements." "Mrs. Palmer?" the judge asked. Patricia stood up, her face flushed. "My husband's business investments are completely separate from my HOA duties. But he does own Meadowbrook Properties, LLC, which has purchased multiple foreclosed homes from your HOA. I don't see how that's relevant. Those foreclosures happened because homeowners refused to comply with community standards." David presented the documents showing the timeline and amounts of the foreclosures. Judge Henderson reviewed them carefully, her expression growing more concerned. "Mr. Morrison," she finally said, "I'm troubled by what I'm seeing here. Setting aside the question of conflict of interest for a moment, let's focus on Mr. Reeves' specific case. You claim his shed violates setback requirements. The survey clearly shows it doesn't. You claim it wasn't architecturally approved, but the evidence shows he submitted a proper request and received no response within the time frame specified in the HOA's own covenants. You claim it's unnecessary, but I have a letter from a licensed electrical inspector stating that weather protection is consistent with National Electrical Code requirements. Where exactly is your case?" Morrison tried to regroup. "Your Honor, the Architectural Committee has absolute discretion under the covenants." "Absolute discretion doesn't mean arbitrary or capricious decisions," Judge Henderson said sharply. "And it certainly doesn't mean discretion exercised in bad faith. I'm going to ask you directly, can you provide any legitimate reason why Mr. Reeves' generator shed should be removed?" Morrison hesitated. "The Architectural Committee determined it didn't meet community aesthetic standards." "Based on what specific criteria?" "What aesthetic standards does it violate?" "The committee felt it was inconsistent with the character of the neighborhood." "But it matches Mr. Reeves' house and is barely visible from the street." "Mr. Morrison, I'm going to be frank with you. This looks like harassment to me. And when I combine it with the pattern Mr. Fitzgerald has presented regarding foreclosures and property purchases by Mrs. Palmer's husband, it looks like something potentially worse than harassment." Patricia stood up again, her voice rising. "Your Honor, I resent the implication that I've done anything improper. I've dedicated 6 years to serving this community and maintaining our property values." "Sit down, Mrs. Palmer," Judge Henderson said coldly. "Here's my ruling. The HOA's denial of Mr. Reeves' architectural request is overturned as arbitrary and capricious. The generator shed may remain. All fines assessed against Mr. Reeves are voided. Furthermore, I'm ordering the HOA to reimburse Mr. Reeves for his legal fees in this matter." I felt relief wash over me, but Judge Henderson wasn't finished. "Additionally, I'm referring this matter to the DuPage County State's Attorney's Office for investigation into possible fraud and conflicts of interest. Mrs. Palmer, I strongly suggest you retain separate legal counsel from the HOA's attorney. This hearing is adjourned." The courtroom erupted. Patricia was shouting at Morrison, who looked pale and was trying to gather his papers. David shook my hand with a huge grin on his face. "We won," he said. "And more importantly, we might have just exposed something much bigger." The next several weeks were a whirlwind. The state's attorney's office launched a full investigation into Patricia Palmer and the Meadowbrook Estates, HOA. The local newspaper, the Naperville Sun, picked up the story, running a front-page article titled "HOA President Under Investigation for Foreclosure Fraud." As the investigation progressed, more details emerged. Prosecutors discovered that Patricia hadn't just been targeting random homeowners, she had specifically chosen people who were financially vulnerable. Janet Kowalski, who had lost her home over the door color, had been going through a divorce and had limited income. Another victim, Thomas Green, had recently lost his job when Patricia targeted him for having lawn decorations that allegedly violated HOA rules. The pattern was clear. Patricia would find homeowners who were unlikely to be able to afford legal representation, cite them for minor violations, refuse to accept any remediation attempts, and rack up massive fines. When the fines exceeded $5,000, she would initiate foreclosure proceedings. Her husband's company would then purchase the properties at foreclosure auctions, typically for 30 to 40% below market value. They would make minor improvements and resell within 6 months, pocketing the difference. On May 15, 2025, Patricia Palmer was arrested at her home and charged with fraud, breach of fiduciary duty, and conspiracy. Russell Palmer was arrested the same day and faced similar charges plus money laundering. The investigation revealed they had profited nearly $3.5 million from the scheme over 4 years. Stephen Morrison, the HOA's attorney, had his law license suspended pending investigation into whether he had known about or facilitated the fraud. His firm, Morrison and Associates, ended up settling with several of the victimized homeowners to avoid further legal action. The Meadowbrook Estates HOA immediately removed Patricia as president and installed an interim board. One of their first actions was to send me a formal letter of apology and to reimburse my legal fees, which totaled just over $12,000. But the story wasn't over yet. The criminal cases took months to work through the system. During that time, David Fitzgerald helped organize a class action lawsuit on behalf of all the homeowners who had been victimized by the Palmer's scheme. In addition to the properties that had been foreclosed, investigators found dozens of other homeowners who had been excessively fined for minor violations. The case went to trial in October 2025. I attended several days of the proceedings, watching as Patricia and Russell Palmer sat at the defense table looking nothing like the confident, powerful people I had first encountered. The prosecution presented overwhelming evidence of their scheme, including emails between Patricia and Russell discussing which homeowners to target, financial records showing the profits from property flips, and testimony from victims. On October 28, 2025, the jury found both Patricia and Russell Palmer guilty on all counts. Patricia was sentenced to 6 years in federal prison and ordered to pay restitution of $2.8 million. Russell received 8 years and was ordered to pay $3.1 million in restitution. Additionally, both were ordered to forfeit all properties still held by Meadowbrook Properties, LLC. The civil class action lawsuit settled in December 2025 for $6.5 million, funded by the liquidation of the Palmers' assets and their homeowners insurance carrier. Janet Kowalski received enough money to purchase a new home. Thomas Green was able to pay off debts that had accumulated after losing his house. Dozens of other homeowners received compensation for excessive fines they had paid over the years. The Meadowbrook Estates, HOA, underwent a complete restructuring. The new board, which I was asked to join but politely declined, implemented a series of reforms including term limits for officers, transparent financial reporting, a reasonable fine schedule with caps, mandatory mediation before any legal action, and an appeals process for architectural decisions. As for me, my generator shed stands exactly where it was installed on March 4, 2025. It's kept my expensive generator in perfect working condition through one of the worst winters Illinois has seen in years. The generator has kicked on 8 times during power outages, keeping my business running without interruption. That $11,000 investment, plus the $1,500 for the shed, has probably saved me $50,000 in lost revenue and saved my generator from weather damage that would have required expensive repairs. The irony isn't lost on me. If Patricia Palmer had simply approved my architectural request, or even worked with me to address any legitimate concerns, none of this would have happened. Her generator shed objection would have been forgotten within a week. Instead, her refusal to be reasonable set off a chain of events that exposed a multi-million-dollar fraud, sent her and her husband to prison, and changed the way HOAs operate throughout DuPage County. Every time I walk past that little shed, I think about how one person's petty power trip can unravel an entire criminal enterprise. I also think about the people like Janet and Thomas who suffered real harm from the Palmers' greed and vindictiveness. At least they got some measure of justice and compensation, though nothing can fully make up for the stress and loss they experienced. The electrical inspector, Ron Matthews, sent me an email after the criminal trial concluded. "Glad I could help," he wrote. "In 30 years of doing inspections, I never thought a letter about generator weather protection would help take down a criminal HOA president. That's a new one for the books." Mike Chen, the electrical contractor, still laughs about it when I run into him. "You hired me to install a generator," he says. "I didn't know I was signing up to be part of a fraud investigation. But hey, I got some great publicity out of it. My business is up 40% because everyone wants to hire the contractor who helped expose the HOA criminals." My lawyer, David Fitzgerald, became something of a local celebrity among homeowners dealing with difficult HOAs. He's been featured in several articles about HOA reform and has taken on numerous cases involving HOA overreach. "Your case was the perfect storm," he told me at a barbecue I hosted to thank everyone involved in the fight. "Most HOA disputes are just about petty rule enforcement. Yours involved actual criminal behavior, which gave us the leverage to really expose what was happening. And it all started because you needed to protect a generator." The Naperville City Council ended up passing new ordinances regarding HOA governance in early 2026, partly in response to the Palmer case. HOAs in Naperville are now required to file annual financial disclosures. Board members must sign conflict of interest statements, and homeowners have expanded rights to appeal decisions to a neutral arbitrator before fines can be levied. I stayed in my house in Meadowbrook Estates. Some people asked if I would want to move after everything that happened, but honestly, I love the house and the neighborhood. With Patricia gone and the HOA reformed, it's actually a great place to live. My neighbors, most of whom had no idea what Patricia was really doing, have been supportive and friendly. Several of them apologized for being cold to me during the dispute, explaining that Patricia had spread false information about me being a troublemaker who was trying to turn the neighborhood into a commercial zone. One neighbor, an older gentleman named Frank who lives 3 houses down, stopped by one evening in November 2025 to talk. "I owe you an apology," he said. "Patricia told several of us that you were installing industrial equipment that would lower property values. She showed us pictures that made your generator shed look massive and ugly. I believed her without checking for myself. I'm sorry I didn't support you when you needed it." I accepted his apology, and we ended up becoming good friends. Frank told me that Patricia had ruled the HOA through a combination of intimidation and misinformation. She would tell board members that certain actions were legally required when they weren't. She would claim to have complaints from neighbors that didn't actually exist. And she would threaten anyone who questioned her with legal action. She told me once that if I didn't vote her way on a landscaping issue, she would find violations at my property and fine me into bankruptcy, Frank said. I believed her because I'd seen her do it to other people. Now I realize she was just a bully who found a way to profit from her position. The experience taught me several important lessons about homeowners associations and property rights. First, always get everything in writing and document every interaction. The paper trail I created, including the certified mail receipts, the architectural request with date stamps, and the email records, was crucial to building my case. Second, know your rights and don't be afraid to fight back against unreasonable demands. Many homeowners give in to HOA pressure because they assume the HOA must be right or that fighting back will be too expensive. But if you're clearly in the right and can find a good lawyer, fighting back can be worthwhile. Third, pay attention to HOA governance and finances. If I had researched the HOA more carefully before buying my house, I might have discovered Patricia's pattern of excessive fines and foreclosures. That information would have either led me to choose a different neighborhood or at least prepared me for what was coming. Fourth, seemingly small issues can uncover much larger problems. My generator shed dispute wasn't really about the shed at all. It was about Patricia's attempt to add me to her list of foreclosure victims. When I fought back instead of complying, it exposed her entire scheme. Finally, there are good people willing to help when you face injustice. Ron Matthews didn't have to write that detailed letter about electrical code requirements. David Fitzgerald could have taken a more cautious approach instead of digging into the HOA's history. The previous victims could have stayed silent instead of talking to investigators. But they all stepped up because they recognized something wrong was happening. My business has thrived since the dispute ended. The stress of the legal battle and the publicity actually led to increased client interest. Several business owners reached out to me specifically because they had read about my case and respected that I had stood up to unreasonable authority. My client base grew by 30% in the year following the trial. The generator itself has performed flawlessly. We've had several significant power outages during severe weather, and each time the generator has kicked on within 10 seconds, keeping my systems running smoothly. The shed has protected it from snow, ice, rain, and temperature extremes exactly as Mike predicted it would. When I had the generator serviced in spring 2026, the technician commented that it was in remarkably good condition for a unit that had been installed over a year earlier. Usually when I service generators that are exposed to full weather, I see rust, corrosion, moisture damage to the control boards, and deterioration of seals and gaskets," the technician said. "Your unit looks almost new because it's been protected. You probably added 10 years to its life by building this shelter." That statement made me smile, thinking about how Patricia had called the shed an unnecessary eyesore. She had been so focused on exerting control that she couldn't recognize a legitimate functional need when it was documented and explained by licensed professionals. In February 2026, I was invited to speak at a homeowners' rights seminar in Chicago. The event was organized by a coalition of housing advocacy groups concerned about HOA overreach throughout Illinois. I shared my story with an audience of about 200 people, many of whom had their own HOA horror stories. After my presentation, dozens of people came up to talk with me. Some wanted advice on fighting their own HOA disputes. Others just wanted to share their frustrations about unreasonable rules and arbitrary enforcement. One woman was in tears as she described how her HOA was trying to fine her for having a wheelchair ramp installed for her disabled son, claiming it violated architectural guidelines. "Don't give up," I told her. "Document everything, get it in writing, and find a lawyer who understands disability rights law. The Fair Housing Act protects necessary disability accommodations from HOA restrictions." The seminar organizers told me later that my advice helped that woman successfully fight her HOA, which backed down immediately when her lawyer cited federal disability law. Throughout 2026, I followed the implementation of the HOA reforms in Naperville. The new regulations weren't perfect, but they made a real difference. The requirement for conflict of interest statements prevented board members from having financial interests in properties within their HOAs. The financial disclosure requirements made it much harder for anyone to hide profiteering schemes like the Palmers had run. And the expanded arbitration rights gave homeowners a realistic way to challenge unreasonable decisions without having to file lawsuits. Other Illinois cities started adopting similar reforms, and by mid-2026, there was talk of state-level legislation to regulate HOAs more strictly. I was contacted by a state representative who wanted my testimony for a committee hearing on proposed HOA reform legislation. I testified in Springfield in August 2026, explaining my experience and advocating for stronger oversight of HOAs across Illinois. The legislation, called the Illinois Homeowners Association Transparency and Accountability Act, passed in November 2026 and went into effect in January 2027. It included many of the provisions from the Naperville ordinances, plus additional protections like mandatory notices before fines could be imposed, caps on fine amounts, and criminal penalties for HOA officials who abused their positions for personal profit. Patricia and Russell Palmer's appeals were denied in early 2027, and they began serving their federal prison sentences. Their story became a cautionary tale in real estate and HOA management circles. Several HOA management companies, including Prestige Property Management, which had managed Meadowbrook Estates, implemented new training programs and oversight procedures to prevent similar situations. As I write this in early 2027, my generator shed is still standing exactly where it was built in March 2025. It's weathered 2 brutal Illinois winters and several severe thunderstorm seasons. The generator inside it purrs to life whenever we lose power, keeping my business running and my home comfortable. The shed's paint is holding up perfectly, matching my house just as we planned. Sometimes I walk out there in the evening, open the shed door, and look at the generator humming quietly on its concrete pad. It's just a machine in a small wooden structure, nothing special or remarkable. But it represents something important to me, the principle that homeowners have rights, that rules must be applied fairly and reasonably, and that standing up to bullies and criminals is worthwhile even when it's difficult and expensive. The neighborhood has healed since Patricia's removal. The new HOA board is reasonable and responsive. They've approved several generator installations for other homeowners, using my shed as a template for what's acceptable. Property values have actually increased because potential buyers like seeing an HOA that has been reformed and is now operating transparently. I sometimes wonder what would have happened if I had just given in to Patricia's demands. If I had removed the shed, paid the fines, and accepted her authority, would she still be running her scheme today? How many more families would have lost their homes? How much more money would she and Russell have stolen? That's the thing about standing up to injustice, even in small suburban disputes over things like generator sheds. You never know what larger impact your actions might have. You fight because it's the right thing to do, because the rules matter, because fairness matters, because homes and families matter. And sometimes, if you're lucky, fighting for yourself helps protect others too. My backup generator shed is still there, protecting my equipment exactly as the electrical inspector said it should. And every time I look at it, I remember that doing the right thing, following the rules, and standing up to those who abuse power is always worth the effort, no matter how difficult the battle becomes.